once they get a second DUI. But they are saying, we'll deny you the right to keep and bear arms. These are issues that people aren't aware of. Most people don't even realize, and this is really, really an issue, most criminal defense attorneys don't know, and to the extent criminal defense attorneys don't know, even fewer DAs know, and even fewer judges know, that a misdemeanor 1 in Pennsylvania will cause you to be federally prohibited from being able to own any firearms. Misdemeanor 1. Also, a lot of people are surprised to learn, misdemeanor 1 is the highest grade misdemeanor we have, with misdemeanor 3 being the lowest grade. Most people are surprised to learn if you have any misdemeanor crime, that includes as low down as a misdemeanor 3, that involves a domestic partner in violence, you are federally prohibited. There was a case that recently went up where it was disorderly conduct that can be charged as a summary, which is a traffic ticket, or a misdemeanor 3. It was charged as a misdemeanor 3. And the individual basically what happened is it was convicted at the magistrate's office because the magistrate can hold a trial in relation to a misdemeanor 3 and a guilty plea. And he didn't appeal. No one thought anything of it. It's the lowest grade misdemeanor. Couldn't possibly be prohibited. The problem was, when they charged it, they didn't specify what subcategory of disorderly conduct he was being charged with. And one of the subcategories is a kick, punch, shove. Okay. So, with this, the Commonwealth Court looks at it and says, you know what? There was no testimony taken. So we don't have the background to whether there was a domestic partner. But in the affidavit of probable cause, it said the person that was involved in this incident was the girlfriend. So we're going to take that and establish that we have a domestic situation. And because no subcategory was specified, we're going to assume that it could have been a kick, punch, shove, so we're going to prohibit the person under federal law. These are the type of situations where someone who just gets involved with something minor all of a sudden becomes prohibited because their attorney doesn't know, their district attorney doesn't know, the judge clearly doesn't know. I've been an avid supporter of trying to get a bill passed where if someone became prohibited, they'd have to be notified by the Pennsylvania State Police. We have so many occasions where someone believes they voluntarily admitted themselves to a hospital for psychiatric help, and the hospital processes it as an involuntary commitment. Now they're federally prohibited and state prohibited. It happens more than you believe. I have an incident with a Pennsylvania state trooper. He is top-notch with a firearm. He scores in the top 10th of a percentile within the entire PSP. About 10 years ago, he was going through a divorce, had a rough time, checked himself into the hospital. Guess what? They involuntarily committed him. And you may say, well, hold on, you just said he's in the top 10th of a percentile. Yeah, guess what? There is an exception in federal law that says that if you're in your official capacity as law enforcement, even though you would be prohibited, you're not. So while he's on the job, he has an AR-15, he has a Mossberg, he's got the Glock, and there's no problems. As soon as he clocks off, he cannot possess a firearm. We currently have that up on the appellate courts before the Superior Court. How can that be? The problem with the whole case was the fact that another attorney started representing him, didn't understand the issues at play, got him restoration of his firearms rights as far as Pennsylvania was concerned, but didn't understand that there was a federal disability. So he never asked the judge for expungement. Absent the expungement, he still suffers from the federal disability. He then came to me. We filed a motion for expungement. The judge who issued the decision restoring his rights had retired. A new president judge came in, who the case was assigned to, and without hearing, denied my client's motion for expungement. No hearing, nothing, just nope. So now we have that case up on appeal. That's how things like this can go awry very quickly. and it can make absolutely no common sense. But I understand, obviously, we have a lot of time constraints. I had told you about that when we started. I do firearms law seminars quite frequently. You can follow the blog. Real quick, I just wanted to allow Tom a quick minute to go over these two or three bills that are currently in the Judiciary Committee that you need to be aware of.
Josh is truly at the tip of the spear when it comes to fighting the ATF on firearm laws, including the sheriff's departments that want to keep your guns from you. He's truly the tip of the spear there. What his partner here, his co-worker, is about to tell you about, you probably don't even know that's in the House right now. He's referred to the committee on February 5th. A couple of bills there. I'm going to let Tom take over with that.
Thanks, Tom. I want to first thank everybody for coming out. This is very important stuff that too many people sit back and don't pay attention to. And Mark being the tip of the spear in this, absolutely critical. My name's Tom Beveridge. I work with Josh at Prince Law Offices and the Firearms Industry Consulting Group. Josh does more of the individual rights and takes the lead on liaison stuff with the ATF, if I use the liaison term loosely. I do more of the corporate work, where we have clients that want to start firearms businesses. I help them set them up, help them get the paperwork together, make sure it complies with the ATF requirements. When it comes to contracts and leases and stuff like that, I take care of those types of issues. We also do a lot of nonprofit work for sportsmen's clubs, making sure that their bylaws are up to date and up to speed so that they don't get shut down by a lawsuit. We deal with waivers and all kinds of stuff like that. So what I wanted to talk about today is a couple of bills that are in the Senate, one in the Senate, one in the House, and then another one I found this morning I think you'll find interesting. Before I do that, I grew up in Elk County, Pennsylvania, and I'm not a member of Duck Dynasty. I know I'm starting to look like it a little bit, but I grew up in Elk County, Pennsylvania. I was born and raised up there, worked in a family gas station all my life. Mom raised me. I hunted, fished, and trapped, and I did it for food, and I did it for money. My grandfather gave me my first 3 guns when I was 5 years old, and he was on his deathbed. And he told me, boy, don't ever let anybody take them away from you. Now, those 3 guns aren't covered by this particular bill, but damn well could be if we're not careful. The first bill here, Senate Bill 435, is pending in the Senate Judiciary Committee. And what I mean by that is a Judiciary Committee. The House has one, the Senate has one. And these are state bills, these aren't federal bills. The House has one, the Senate has one. The definition of what they are to do is to recommend fair and balanced legislation that will deliver justice. Okay? That's what they're supposed to do. Here's what this bill has to say. This was introduced on February 5th of 2013. Everybody that introduced it save one. There were 8 members that introduced it. 7 Democrats, 1 Republican. This would amend Title 18, the Crimes Code, and it would read that, except as otherwise provided in this subsection, and we'll talk about the exceptions, I think you'll find them interesting too. No person, and in Pennsylvania, a person is described as a corporation, partnership, limited liability company, business trust, other association, government entity, estate, trust, foundation, or a natural person, shall possess, manufacture, import, sell, or transfer any Class 1 assault weapon or large capacity magazine. Now, that means us, okay? The exceptions to this, who's allowed to do that? The exceptions are constables, sheriffs, prison or jail wardens or their deputies, policemen of the Commonwealth, its political subdivision, or all other law enforcement officers. Period. No restriction on it. Okay?
Tom, I have a quick question for you. Can you define the Class 1 as
Yeah, the Class 1 assault weapon, the definition of that's included in this bill, is any of the following. 1, a semi-automatic center-fire rifle capable of accepting detachable magazines and a pistol grip protruding conspicuously below the weapon's action, or a thumb hole folding or telescopic scope, or a flash suppressor, or grenade launcher or flare launcher, or a forward pistol grip, or a semi-automatic center-fire rifle with an overall length less than 30 inches, or a semi-automatic center-fire rifle with a fixed magazine capable of holding over 10 rounds. That's not it.
So,
Let's move away from the rifle for a second.
so wait, I got a question real quick. I'm sorry to interrupt.
Yeah.
So it's an automatic rifle with one feature.
Semi-automatic.
Semi-automatic with one feature.
Mm-hmm.
Okay.
It has to be capable of accepting a detachable magazine and one of those other features I read off. Now here's where it gets interesting. This is also a Class 1 assault weapon. A semi-automatic pistol capable of accepting detachable magazines and one of these things. A threaded barrel, a second hand grip, a capacity to accept a detachable magazine at some location outside the pistol grip, a Luger, a shroud attached to or partially or completely encircling the barrel, allowing the bearer to fire the weapon without burning his hand, except for a slide enclosing the barrel. Or a semi-automatic pistol with a fixed magazine having the capacity to accept over 10 rounds. We're not done. I got one more category for you. This is also a Class 1 assault weapon. A semi-automatic shotgun having one of the following. Folding or telescopic stock. A pistol grip protruding conspicuously beneath the action of the weapon. A thumb hole stock, or a vertical hand grip, or the ability to accept detachable magazines, or a revolving cylinder. Now, I just happened to be on Cabela's website the other day, and I love to hunt turkeys. I'm a predator hunter, mostly. I love hunting coyotes and stuff, and so I'm always looking for new stuff in that, but I like to hunt turkey. Well, Stoker's came out with a 12 gauge, and I don't know if anybody's seen this, but it's a semi-automatic 12 gauge, and it's got a pistol grip and a thumb hole stock, and you can get all these different things and stuff like that, and it's beautiful. And when I read this, I would close the magazine. I can't even get near it now. Not law yet, but it could be. So, I want to talk about this other exception, because this is where it starts to get interesting. I'll take your questions at the end. This is where it gets interesting. I read you the first exception about constables, sheriffs, prison guards, etc. No restrictions on what they can do. Members of the Army, Navy, Marine Corps, Air Force, Coast Guard of the United States, or of the National Guard, or organized reserves, when they're on duty. When they're not on duty, they can't own an assault weapon if under this classification. And here's the one that's really interesting. Officers or employees of the United States duly authorized to carry a concealed firearm. So if my postman has a license to carry, he can have an assault weapon, I can't. Under this law, if it passed. Grading, your first offense is a misdemeanor 1. Your second offense is a felony 3. Now, the other thing about these Class 1 that I talked a little bit about under the Senate bill is the definition of a large capacity magazine. That is any detachable ammunition feeding device with the capacity to accept more than 10 rounds of ammunition. There's some exceptions to that. I won't get into them. But that's the Senate bill. Now let's talk about the joke. Here's the joke. Here's the House Bill 517. Again, Committee on the Judiciary, February 5th, 2013. Proposed by 19 Democrats.
Okay.
19 Democrats.
All from Philly, right?
The majority, I will tell you, all but maybe 5 are Philadelphia Democrats.
I'm shocked.
There's a Lackawanna Democrat, a Lehigh Democrat, a Luzerne Democrat, Delco, Monco, and Bucks. So, And this one is pending in front of the Judiciary Committee of the House. Under this law, certain assault weapons are prohibited. A person, same definition, may not do any of the following: possess, use, control, sell, transfer, or manufacture, or obtain a license to do any of those things. There goes your right to an FFL, Class
Gun
3.
shops, folks. They're trying to get rid of your gun
They're going to
shops.
shut your gun shops down. And that's exactly what it would be. Person defined as a corporation or a company. If they got a license, they're in violation. The exceptions here, very similar to what the exceptions were before, except there's not those crazy restrictions on, the postal employee can have an assault weapon and I can't. The definition of assault weapon under this bill, a little bit different, means any selective fire firearm capable of fully automatic, semi-automatic, or burst fire at the option of the user. Okay, maybe we could all pretty much agree. Somebody's got a fully automatic selective fire weapon, you should have a Class 3 for it.
No.
Well, I'm trying to be a little bit, I don't agree with that, but I'm trying to be a little bit. Or, and here's where it gets interesting, any of the following specified semi-automatic firearms. And it goes into a list of firearms that include, I'll just read off a couple. The Armalite AR-180, MAC-10, MAC-11, MAC-11 carbines, Ruger M14 5F, folding stock model only. The Scorpion Scarabs, AKs, bunch of other stuff in here. Even they included the Wilkinson Linda pistol. I don't know if anybody's ever seen one of those. I don't know where they came up with that, but... And it gets into these pieces, which is absolutely hysterical. A part or combination of parts designed or intended to convert a firearm into an assault weapon as defined in paragraph 1 above, or any combination of those parts. Now that would mean that if we left here and we were talking and I said, hey, I got an extra pistol grip for an AR, or I got a pistol grip for your semi-automatic shotgun, make it easier to work with and stuff like that, this bill were passed, you're in violation. Just because you have that part. It also defines any semi-automatic firearm not listed in paragraph 1, those specific ones, that have the following criteria. A semi-automatic rifle that has the ability to accept a detachable magazine and has at least 2 of the following: folding or telescopic scope, pistol grip, bayonet mount, flash suppressor, threaded barrel, grenade launcher. Semi-automatic pistol that has the ability to accept a detachable magazine and has 2 of the following. Then it goes through a whole bunch of that stuff, including one interesting one there that says a manufactured weight of 50 ounces or more when the pistol's unloaded. And it includes a semi-automatic shotgun that has at least 2 of the following: a folding or telescoping, you know what I mean, scope, a pistol grip that protrudes conspicuously beneath the action, fixed magazine capacity in excess of 5 rounds, and ability to accept a detachable magazine. And then the catch-all, a part or combination of parts designed to turn it into an assault weapon. The only thing it excludes there, it doesn't exclude your collections, your antique firearms, anything you're licensed already to have, or anything like that. What does it exclude? It excludes this. Quote, the term assault weapon does not include any firearm modified to render it permanently inoperable. The final one I wanted to tell you about was this.
Real quick, guys, you're going to want to listen up to this bill. This is a serious bill. If you think your rights in Pennsylvania here are not under attack, think again. They are we are under attack, severely under attack for our Second Amendment rights. Not that it's a right, it's our God-given right. You want to pay attention very closely to what this man's about to tell you.
Before he gets into that bill, the one thing that needs to be said with both of those bills he reviewed, there is no time period for which people can actually turn in their weapons or otherwise. Every one of us would automatically be subject to criminal charges for a misdemeanor 1.
I have an answer to that. I don't think there's enough jail cells in Pennsylvania to get us all.
We cling to our guns and to our Bibles. So.
Yeah.
What's the number of that bill?
That's House Bill 517. The other one is Senate Bill 435. This one I found this morning while I was having my coffee and eggs. This is House Bill 961. It almost made me sick when I read it. This was referred to the Committee on the Judiciary on March 12, 2013, and I'll bet nobody in this room has heard about it, even being before the Pennsylvania Congress. This bill is titled Unmanned Aircraft Surveillance. An order authorizing unmanned aircraft surveillance. Basically what it says is from the Attorney General all the way down to Assistant District Attorneys can go and on written petition to the Superior Court of Pennsylvania can apply to get unmanned aircraft surveillance, otherwise we know them as drones or kites, wherein there is suspected criminal activity, has been, is, or is about to occur. Okay? No mention of probable cause. No mention of reasonable suspicion. No mention of evidence required. Witness testimony. Due process rights. What it says is they can go and get this when such evidence may provide, or when such use may provide evidence of the commission of any of the offenses enumerated under the Wiretapping Act, or may, not shall, may provide evidence aiding in the apprehension of a perpetrator or